Yeah. So hello, everyone, and welcome. Today is our third bi-weekly happy hour, and we're here on Cinco de Mayo to talk about video hearings. I'm Melissa Kaczynski, and I'm here with Brian Karp and then two distinguished speakers who will introduce you to momentarily. And just to get us started, the hope is that Brian and I could just chat a little bit about what's been happening in the past 2 weeks since we last visited with you. And please feel free to join us. We all have some margaritas to celebrate Cinco de Mayo. And let's get started. So Brian, how have the last 2 weeks been treating you in the technology front?
It's been good. I think things are slowly progressing. I'm learning new kinds of software. In my office, we actually just switched over to a new document management system. I mentioned this a few weeks ago. We're finally in play, and so that's been good. Certainly some learning curves, but thank heavens for tech support. My office, I think, is finally learning that I am not tech support, and I am based in Florida, and I cannot give advice or help them. So, that's been good. Other than that, I'm having more hearings being set, actually, more mediations. I think people are getting more and more comfortable with the use of technology. And the other thing that I'm hearing more is that nobody ever really wants to go back to an office. People that I thought were going to be those kinds of lawyers that couldn't wait to get back into a building are actually seeming to enjoy their time working from home and finding it more productive. And so am I, frankly.
Yeah, I think there's going to be a whole shift in the way that our law firms are going to manage things going forward in the future. The type of leases we sign with buildings, the type of leeway we have to give to staff and other attorneys to work from home. And then I think the expectation for our court system is going to be a little different going forward. In fact, yesterday, the US Supreme Court, for the first time ever, held live hearings that anyone could listen into. And all of the justices took oral argument by telephone. And of course, we were talking about this right before we logged in. And Jaime, as you mentioned, Justice Thomas spoke. So for the first time, I think most of us got to hear him ask a question, which was very interesting from a legal perspective. So, this is something that is going forward. And I'm not sure if anyone else listened to any of the hearing. I did. It actually flowed pretty well. They had a process in place. And while it's, probably a little intimidating, they did the argument extraordinarily well. And they had the questions pretty well by each judge from seniority down the line. So they took their turns. And you could hear it. I didn't hear many tech hiccups. So
they probably should have called us.
Maybe. I really kind of wish it was a video hearing, because I really would have loved to see what RBG was wearing. Did she have her yoga pants on? I'm not sure.
It's got to be. Well, and is it, Melissa, is it 2 weeks? Are we doing our technology tools, or are we doing that in 4 weeks?
So in 2 weeks, we're going to, at our next happy hour, we're going to have two folks join us about how to decompress from tech overload, because I think all of you are probably realizing we're just getting a little too much technology over these last month and a half, 2 months. And so they're going to help us, albeit using technology, figure out how to de-stress from all of our work from home tech woes.
Okay. Well, and following up from there for everybody, and I think it's going to be a popular one, is we're going to start actually maybe every other or every third session that we do, we're going to have a focus on more technology tools, applications, software, things of that nature, and we're going to try to theme them. So 1 week maybe practice management software, another one maybe communication tools, another one maybe how to link your office from home and tools that make your documents more accessible, things of that nature. So stay tuned to those.
Yeah, so why don't we get to what we're here for today, and that's our discussion on video hearings. We have two amazing attorneys joining us today, both who have had hearings via video during the pandemic, and they're here to share with us their experiences. So we're joined by Jaime and Jelena, and we can start off by asking a little bit about each of you, and then get into what your experience actually was. So let's talk to Jaime. Tell us a little bit about your practice, and then we'll hear from Jelena.
Thanks so much. My name is Jaime Webner. I'm an attorney in Miami, Florida at the firm of Young, Berman, Karp & Gonzalez. I do primarily commercial litigation. It's a very varied practice, a lot of business contract tort disputes. And in addition to that, I do also a lot of probate litigation. So not the administration aspects, but litigation arising out of wills, trusts, and those types of disputes. So far during this pandemic, I've had experience with hearings, also again in the probate setting, and also I did my first deposition over Zoom, so I can talk to you guys a little bit about that as well.
Wonderful. And Jelena, how about you? You're down in Houston.
Yes, yes. So my name is Jelena Kovacevic, and I am an attorney at Jenkins and Kamen in Houston, Texas. I practice primarily family law, actually exclusively family law. Everything from divorce to child custody to modifications. And most recently, my experience with a virtual hearing was a writ of habeas corpus. So that had its own challenges where typically you're asking a court to order a person to appear with a child in a courtroom. And here we are appearing virtually and there's no courtroom to bring the child to. So lots of changes to our practice and the request for relief that we can seek. But the courts are open and available to litigants via Zoom. So I think it's important to get comfortable because we might be doing this for a while.
Melissa, I take exception. You said that Jelena was down in Houston. Not for us. So.
Yeah, we'll say down in Houston for me. I mean, I'm the one sitting in the judge's chair today, so we'll say that.
Okay.
Okay.
So Jelena, tell us about that habeas. What happened?
We were the movant. My client was the movant, and we petitioned the court to return the child to my client during his period of possession. It ended up becoming a safety hearing in which the issue was whether or not my client had a superior right of possession, and then after that, whether or not he should be granted possession of the child. And so there was a lot in terms of evidence and testimony, and to add to the complexity of that is that we had time limits. So originally it was 45 minutes aside, and the court graciously extended it a bit, but it was very difficult to get all of that in a very short time frame.
Was it Zoom?
Yes, it was Zoom.
Because I know certain courthouses, or certain jurisdictions, I should say, are using different services. Some are using Zoom. Melissa, what's that other one? Who was it? It was Kim.
DC is talking about WebEx now. Maryland is using Blue Jeans. So I know there are different platforms no matter where you are. How about Jamie in Florida? What are you using?
Florida's using Zoom also, but I think this just brings up a good important point, is to make sure that you're keeping up to date with the local advisories that I know Brian sent one to our firm today from the Florida Supreme Court that just discussed all of the things that have been implemented and are in place. And if every jurisdiction is using something different, you just need to familiarize yourself with that and make sure you're keeping up to date with the websites. I know down here in Miami-Dade, they've done a good job updating information regularly on their website. I haven't tried to call. I know we've all had challenges ever call, even in a normal day, calling a clerk's office, but I'm sure there's people there that are willing to help and answer questions.
So when you did your hearings, they were video. You actually were physically, you were seeing people. It wasn't just a telephone hearing, right?
And let me just preface that. I think that we can group together for purposes of today, hearings and depositions, because it's going to be pretty similar. We're going to, there may be a difference with evidentiary rulings, but if you have experience with depositions too, just group that in, because it's really going to tie into the same thing in terms of use of Zoom.
Right. So they were.
Sorry, go ahead, Melissa.
No, they were video, right? Depositions, hearings.
Correct.
Okay. Well, what technology do you use at home? Let me say, do you have dual monitors? Do you have special computers, special microphones, blue screens, black screens, green screens, whatever they're called?
Jelena, you.
Okay, thank you. So I use my laptop, my Lenovo with its camera, and I sit in my dining room with this background, and this is just kind of where I've set up shop, and it surprisingly does not require much technology or much equipment. So, just log on to your Wi-Fi, plug in your laptop, and there you go, you're in a courtroom.
Jelena, I like yours. If you don't mind, before this is over, I'm going to have you duck down so I can do a screenshot, and I'm going to make a virtual background of your kitchen.
Perfect.
Do you like my skull? This is my dining room as well.
Oh, yeah.
I
See?
like it.
We could mess with people. We could take virtual backgrounds and make it other people's homes. Okay?
Well, I mean, I heard that there is a Florida judge right now, maybe it's Tampa, where he does these hearings from his garage, and he puts up a virtual background, somewhat similar to the one I'm using right now. And he does his hearings in his robe and has it very formal. And
Well, that was my experience. So the probate judge down in Miami, she had similar to your background, but it actually had the official seal of the 11th Judicial Circuit in Miami-Dade County. And she was in her robe. The funny part was her cat was walking across the table. So her cat kept coming in and out of the background screen. Because as you guys know, if you use the background screens on Zoom, sometimes if you back up, you get lost in whatever screen you put behind you. So we just had a cat coming in and out of the hearing, which like, as long as it wasn't my puppy, it was fine, but.
How distracting is that when you're trying to do a hearing and you see that type of thing?
It was distracting, but I think something else to remember is to keep everything pretty lighthearted and be understanding, right, during these times, because we're all going to have those hiccups. So we were at a point of the hearing that it wasn't, an intense moment that we couldn't all just laugh off the distraction.
Speaking of that, so I would say I'm traditional with being in court. I like to stand up. I like to walk around. If my opposing counsel's sitting at the table, I don't do that. And so that's one of my adjustments right now is sitting behind a desk, typically without pants and typically without shoes. Okay, and so there's a mental game as part of this. Now, the few hearings that I have done, and I haven't done, I had one that was going to be evidentiary, and we wound up just not making it evidentiary. But I've done several that are regular argument, and I'm not necessarily opposed to the lackadaisical nature that there is. I almost feel comfortable in a way. Now, I like to interject and I like to do things, so it's hard to sit here and not do very much. But how have you guys dealt with that? I mean, what has your style had to change? Are you comfortable sitting versus standing, or being at home versus in a courtroom with the wood and everything else? Does that come into play at all?
Jamie, do you want to?
Good.
Sure. No, I was looking at Jelena, not that she could see that I was looking at her, but a lot of our hearings, and especially some of the quicker ones, we tend to be sitting down or maybe in chambers. So it hasn't been a big change for me. I know at the article that I read about the U.S. Supreme Court argument, they were talking about people having lecterns in their houses and kind of still trying to treat it, because maybe if you're used to arguing in front of the U.S. Supreme Court, you're used to the formalities of standing and at the lectern and having all of those things. So, whatever makes you comfortable, because we're obviously all in an uncomfortable and different space. So I think whatever but I've just been sitting because I'm comfortable sitting, and usually have leggings on also, but I put actual pants on, unlike Brian.
To each their own.
Well, I would just say the way that I think that my practice has changed quite a bit, but in terms of how I handle a hearing, especially an evidentiary one, I'm one of those lawyers that still writes out my questions, at least for a direct or a cross that I know that is coming and points that I want to make. And so trying to manage exhibits for an evidentiary hearing, especially one where I know that there's time constraints, I found it helpful to refer to the exhibit in my question, so I know where I'm going, because it's not like I have a stack of my exhibits out before me. And I find it helpful to go ahead and have them arranged in the order that I plan on referring them to, so that when I share my screen, I'm able to kind of quickly switch from exhibit to exhibit. And if I'm going through a decree, which might be 45 pages, and I want to refer to a specific section of it or a specific line of it, I already go ahead and I have it open to that page, so it's faster for purposes of reference and admitting it. So
Jelena, when you do that, with your exhibits, does your jurisdiction require any kind of pre-hearing exchange or disclosure? How did that go about?
So interestingly, the day of our hearing, the court issued new rules on that. But the way that we handled it is that I sent my client the exhibits ahead of time. And so that when I referred to an exhibit, he had it in front of him, so he knew what I was referring to. And I also sent my exhibits to the opposing counsel. So for purposes of laying the proper predicate and authenticating it, we knew what exhibit I was referring to without the court actually seeing it.
And then you use the screen sharing function on Zoom.
Yes. So once I, laid a proper predicate and asked the court to admit it into evidence, only then would I actually share it with the court to see, because opposing counsel had his own set of my exhibits, my client had his own set of my exhibits, and so it was just for the purposes of the court in order to share it so that we were all looking at it on the screen.
And so the court looked at it on the screen. Did you also email it to the court so that they had it then in evidence?
Yes, after the fact, yes.
Okay.
So, but the initial review was limited to being on the screen.
Well, the initial, so.
For the judge.
Yes.
Were any of the documents that you were using, were they voluminous? I mean, did you have to pause and allow the court to review the documents?
Well, no, not in this situation. And all the exhibits that I had, I didn't end up using because, again, at the time constraint. But what I tried to do is, like I said, turn to the page of the document that I know I was going to be referring to. And luckily there weren't objections launched into various sections of the document, so we had to go through it one by one or page by page. So I didn't have that kind of situation in this hearing, but I could see that coming up in other evidentiary hearings.
And I think certain judges, at least where we are down here in South Florida, they all have their own procedures, but what I'm seeing tends to be commonplace is that you can exchange exhibits in advance. So maybe 5 days before the hearing, both sides exchange. You have them marked. You label which ones are agreed to versus which ones are disputed. Okay, and at the same time, the judicial assistant gets a copy, and so the judge at the time of the hearing already has the documents. One of my concerns with the judge not having the documents is, and this is, to me, this is one of the keys of actually being actively engaged in the middle of a trial. There's a lot of times, if you notice, the judge will be sitting reading something and the other side will be going off on their questions on an important point, and there's no way the judge is able to actually read that document at the same time that they're listening to this important testimony. So I think having the documents or maybe using pauses and breaks would be a good tool for this, right?
Definitely.
And then what about objections? Have either of you guys seen any unreasonable objections, let's say to authenticity or something that, maybe a litigant is using the Zoom process to their advantage? No?
I can't say that I've seen that.
I have not, but I think this type of world, it seems like this is something that what Jelena kind of just talked about is making sure everything's sent in advance. I think people, and this is maybe something for courts to develop procedures for pre-vetting, doing the objections ahead of time so that you don't have those types of disruptions, particularly in the case of where Jelena had a limited time frame and you would have just eaten up the entire clock dealing with, back and forth of who's talking, who's objecting and responding to that. But, we're all just evolving in this, and courts as well. So hopefully, procedures like that get implemented and they're useful and helpful for everybody. But I think that's just, again, just making sure you're up to date on all the procedures and all the information that you need.
So Jelena, when you did it with their screen sharing, did you have all of your exhibits lined up, let's say in Adobe or something? Because if you do screen sharing with Zoom, you have to actually click your open window, right? So you only have that active window being shared. How did you make it fluid going from one document to the next or one exhibit to the next while also having your questions that you write out handy?
Well, I tried to make it as fluid as I could, right? And so because I organized them in the order that I thought that I would utilize them, it made it easier to go backwards and forwards. And also because I had it written out into my questions what exhibit I was referring to. In court, I would have an exhibit list in front of me and I would have my whole file, my Redwell with all my documents there ready to go. And so maybe because I'm more of a document hands-on person, it was harder for me to do that without having documents. So that's why I think I needed to take the extra step of writing all of that in. But, there's definitely, ahead of the hearing, I knew that I would struggle with the screen sharing aspect. And so I just kept practicing in my own Zoom session of trying to go back and forth and seeing, what does it look like when I click on this, and what can somebody else see? So yeah, I basically set up two Zoom accounts so I could go from one computer to the next to see what did it look like if I clicked on this exhibit? What did it look like if I, try to go to a different one? What does a court see, or what does everybody else see?
Well, and I would think that a second monitor would make life much easier with this. I mean, I have my home workstation that I've rigged here with like 3 tables that don't match. I have 2 monitors. And so the way I've done screen sharing before is I have 1 monitor that is solely my exhibits and solely whatever I have to share on the screen. And then on the other screen, I can have my questions, or, the hearings I've had to have like an Excel document open at the same time as a PDF. And so I'm using both monitors. And the other thing that I've done is, and it's interesting because I'm a Mac user at home. I have MacBook, iPad, iPhone, but for the office, we're primarily PC. And so I've almost given up on Mac at this point. It's too hard for the office. And so at least in Windows, you can do something, I think it's called Snap, where if your monitor's enough of real estate to actually see things, you can split your screen into multiple smaller monitors. So in one monitor, you can have a PDF, and on the same side maybe an affidavit. So they're right next to each other. And so by all rights, I actually have like 4 screens the way I did this. And so I think that would be helpful for anybody to have one dedicated area for exhibits and then another dedicated area for whatever you have to scroll through.
I can absolutely see how practice is going to be necessary for this, because I would be terrified that if I did not practice and practice and practice, that I would get to the hearing and accidentally everything just shuts down, or I lose the documents, or something crashes, or that's the day that my Wi-Fi.
Or you give your whole opening statement and you realize you were on mute the whole time.
Yeah, I know. I mean, I see a lot of room for error and hiccups, and I'm hoping that the courts are going with the flow and realizing this, and I'm hoping that none of the hiccups, at least the ones that I anticipate I will be making, are going to be detrimental to my client in some way. So, I mean, another hiccup that I see, did either of you have any witnesses for your hearing? Did you call witnesses for the hearing?
Yes. There was even, expert testimony. Yes. Yes.
Oh my gosh. So they had to be patched in at the proper time to your hearing?
So the way that it worked was the court tried to swear everybody in at the beginning of the hearing, and then we invoked the rule, and they were sent off into, one of the interweb meeting rooms and basically waited until they were called. Okay.
So you use the Zoom function of breakout rooms?
Yes.
And I'm not sure what other platforms use that are similar to that.
Who was controlling that? The court was putting them out in the, okay.
Yes.
One less thing to worry about.
The court takes care of that.
Exactly.
Well, our courts, I just pulled up. So for instance, the Miami-Dade court, they have a whole procedure for this. At least 7 days before the hearing, it identifies what you're supposed to exchange with your opposing counsel. And they actually created a form that you fill out. And you put the parties' names, the name of the court reporter, description of the exhibits, and then it marks down whether the exhibit is just for identification or whether it actually comes in evidence. And there's a whole checklist for you as the litigant to be able to fill it out. And so if your jurisdiction does not have this, if you want it, somebody wants it, just contact me, email me. I'm happy to share the one that our jurisdiction uses, because it's usable. It's a blank form. You can use it in any court. And I think that would help too, because not only are you reading exhibits and looking at your questions and dealing with the judge, but I write down the numbers of all, or the letters of all of my exhibits. So I have my own exhibit list as I'm running. So there's a lot of moving parts. The other thing that would probably be helpful when you can do this, although it's tough to do, we typically, if I have a major hearing going on, you may have somebody else in your office participating. So Jelena, I'm sorry. Was it just you? I told you I was going to do that, Ms. Graves. Was it just you in the hearing, or did you have somebody else in the office helping you?
It was just me.
And Jaime, I can probably already know your answer because I know who you work with. So it was just you too, I assume.
It's just me.
Would it have been helpful for you guys to have had somebody else, whether it's a law clerk, an assistant, somebody at least participating behind the scenes with exhibits, or maybe moving your exhibits for you? Is there something like that would have helped?
Jelena?
for me, no. I needed to be able to, and maybe as more comfortable this becomes, and as better I get at it, maybe that I could rely on our staff as I typically do. But for me, I just needed to be able to control the situation myself.
Type A.
Yeah.
You're
And
type A.
I mean, mine was an evidentiary, so I wouldn't need a second hand, but I think it would just be hard because you're trying to make sure what's being put on the screen is the correct document. And so you have it all laid out there. And if you're relying on somebody else, then that just adds another layer of potential error. So it's probably something, and maybe that's also just my personality to do everything myself. But yeah, it's probably something I would just need to handle because, like Jelena, I need to be able to see what I'm looking at, what I'm referring to. But I know, for example, in the deposition that I had, I was actually defending it. And so opposing counsel sent us the exhibits only 12 hours in advance. So I wasn't too excited about that. I asked for a couple days, but he didn't follow up to ensure that the witness had all of the exhibits. So although his assistant sent a full list to myself and the other defendants counsel, the witness was like, I don't have exhibit 17, I don't have 19. And so I think it just shows preparation is really key. Giving yourself a couple extra days to exchange things with either your witness or your witnesses if you're doing a hearing, or opposing counsel is important, just to make sure that you have all of your T's crossed, your I's dotted.
Jaime, your court reporter, I assume, were they at home?
Court reporter was at home. She had to see the witness's driver's license, and the witness was like, well, I don't have it, it's upstairs. And she's like, it's obviously a requirement for them to, especially in this type of setting. But there was a couple times that certain counsel didn't have their microphones muted, so they had to mute so that there wasn't the feedback and we weren't like hearing, double. But other than that, it went smoothly, except for my own personal tech issues.
What about one witness talking over a lawyer or vice versa? Did you have that a lot, like you do in a normal deposition?
It was pretty clean. There was just a few objections. Maybe if it was a party, it would have been, there would have been more back and forth and more objections and things. But I had a couple objections and I just chimed in quickly and then went back on mute. So we didn't have any issues. We were fortunate, except my internet was going out. So I got knocked off, had to email my, the other defendant's counsel and said, I'm knocked off, hold up, wait for me, got back on, got knocked off again. So had to quickly adjust and sign in on my phone. And that wasn't ideal, but I think that's just an example of the way that we all need to be able to sort of adapt in these times, because we don't have power or control over our Wi-Fi connection all the time.
That's actually a really interesting point. So to what extent should we have contingency plans put together? If you're on your computer and something goes out, should you have a laptop or an iPad or a phone? I mean, the good thing about Zoom is it's on every device. But if something goes down, it is probably helpful to have at least a plan, or at least a way to contact someone. Hey, I'm kicked out, in case you didn't notice, or I can't hear, or something like that. So, and speaking of which, here's something that I have learned. If you are not the meeting host and you mute yourself, many times based upon the settings, you cannot unmute yourself. Okay? So you either need to hold up a sign or wave your arms in the air. Right, Melissa? How many times have I done that? Hey. So,
right.
That's something to think about too. And again, I think trial runs and practice are very important when you do these things.
Now, how did you prep your clients for this type of hearing? I mean, because that would be really disconcerting to my clients if they were sitting there and they wanted to ask me questions and I was arguing a case on a computer.
I think it's important, kind of what we do before any hearings. I mean, when you're in court and you're sitting next to your client, there's a level of comfort and a level of feeling like, well, at some point we'll take a break and we can communicate, or you can write me notes. But at the end of the day, it's just like any other hearing. And when they're on the stand, you can't talk to them anyways. So it's about that preparation and trying to coach them on, okay, it's going to be just as if you were in a courtroom. You need to look professional. You need to find a place in your house or your office or whatever it might be that you're quarantining. that is quiet and that is not going to be a distraction. You know, most people have kids at home or spouses, and trying to prepare them as best as you can about what to expect, who you think is going to be called, what exhibits you think are going to be important, sharing those exhibits ahead of time and saying, okay, when I ask you about this document, here's, you know, what we're going to be looking at and what kind of predicate I need to lay if there's an objection by opposing counsel. So
but also making sure they know the technology. I mean, you don't want them typing messages to you on the Zoom or web platform that might then get saved by the court at a later date.
Well, luckily, we did not get to the point of, you know, send me messages via chat or even send me messages on the phone. I feel like we're communicating right now, and it's not even the intense pressure of a hearing. Like, what, you know, I'm not going to have my phone out trying to like text something to my client or to anyone trying to communicate. So I don't know how feasible, or at least that wasn't for me.
Right. So expectations.
I think so, and communication and preparation.
Well, and also, so I mean, especially if you're in a deposition and if you're deposing a party, let's say, or even in a hearing, you got to watch probably to see if the witness has any kind of documents in front of them or note in front of them that they're not supposed to have. So, you know, one of the things is probably wise to do is to watch the eyes and see if somebody keeps looking down, it looks like they're reading, you know, you may want to answer that question because, you know, evidentiary wise, it's something to watch for. And these are things that we're just going to learn from trial and error.
Right.
Okay.
How did the courts prepare you for this? I mean, did you have a lot of interaction with your courts in advance about this is the platform we're using, this is the rules, this is, you know, what we have to do, this is the number to call into? Did they share a password with you that you shouldn't share with anyone else for the platform?
I'm just going to go on a limb. And Melissa, maybe you get to practice somewhere really fun. I'm going to guess with the two of you ladies, the answer was 0.
Well, our hearing was scheduled before we went on lockdown and the courts closed. So we just received a follow-up email from the JA who, you know, issued all of the Zoom details for dialing in. They set it up themselves. And my co-counsel ensured that there was one pro se litigant that was potentially a still interested party. So we just did our extra, you know, due diligence to make sure everything was delivered to her and that we had evidence and proof of that. But they were helpful and you know, gave us all the information that we needed. And that was basically it.
I'll say that our court, the court that I landed in, or that I am in, was actually really helpful because you know, this was a brand new action and I had to set notice of a hearing and I didn't know how to set notice of a Zoom hearing. You know, how am I going to get the login information and what is the expectation? And, you know, if you serve subpoenas, like, can you really expect a person to download Zoom and to sign in at this time like they're required to? And so the court was really helpful in giving us that information, you know, making sure that it was clear, you know, what the Zoom instructions were, what the login information was, and getting it all set up. And lo and behold, people appeared like they would have in a courtroom.
And my understanding is Texas actually put out some YouTube videos in advance on training for lawyers.
Yes, and in fact, I think in the week before or like the week of my hearing, the judges got together and held a webinar, much like this, in which they allowed us to, you know, put in our questions, and they did a really good job of answering those. And so I felt more prepared, you know, doing that hearing after listening to these webinars and logging into YouTube and watching videos that judges had prepared.
That's great. And I think that, you know, for anybody who has questions or is looking for resources, it sounds like that one, the YouTube ones Jelena just talked about. And also I know Zoom has a help sort of portal that has tutorials for their services too. And so in addition to doing prep things like Jelena did before her hearing, I think it would be helpful and beneficial for anybody who's not totally comfortable with the technology to go through and use those tutorials, because they're there for a reason. And it's just better, you know, way to ensure yourself that you're not going to have any issues.
Well, the other thing that would help is whether it's somebody else in your office or a friend, practice go through and actually have somebody somewhere else, so you're not having to go back and forth to two computers, and try it out. Ask the questions, see what it sounds like if someone's interrupting. Practice sharing the exhibits, make sure you can see them, things of that nature.
Did anyone in your jurisdiction that you know of, or anyone at your firms, express concerns over the security issues or the privacy issues related with these platforms?
Well, it's interesting because during my hearing, I was referring to medical records. And so obviously that contains protected information and potentials for HIPAA violations. And when you're in the zone and you are in a time crunch, you're not thinking about, oh, I'm on YouTube. And this information could be accessible to anybody who might be bored enough to watch. And so things like that, keeping notes in your questions, or like a huge red sticker of like, be careful when you admit this exhibit or you refer to it, and either redact, or if it's not possible to redact, then ask the court to take you offline. And our judge did a great job of basically taking us off of YouTube when we discussed a certain exhibit.
So your judge basically did almost like a sidebar with just counsel. They were able to do that?
It's not really a sidebar. He just took us off of YouTube.
Oh, just public. Okay.
Yeah.
So when you say YouTube, what do you mean?
So they, like we were talking about ahead of time, so in Harris County, they are streaming our hearings live on YouTube.
Wow. Why?
Well, I think the thinking is, or it looks like all of Texas, I think that the thinking is that these hearings are meant to be public, and that just because we're in this pandemic, that should not stop. And so YouTube, I guess, is the most accessible forum to make it public.
So what was happening before the pandemic? Were all of your hearings recorded?
No, but they were open to the public. So, anybody could come into a court of law and observe and watch if they wanted to. And so I think the mentality is, you want to still make that process public as it's intended to be.
And I wonder what would be least obtrusive. Literally live streaming every hearing, or maybe giving out a notice like in a publication, these are the upcoming hearings, and you can maybe request Zoom access or something. I think to have every family law hearing out there on YouTube, and I assume they're recorded, Jelena, and they're there in the future?
They're not recorded. No, I don't believe that you could go back and watch it. I just think that you can watch it live. If they are recorded, I don't know where that is.
And is somebody watching able to record what they're viewing?
I do not know.
I mean, you could always just take out your iPhone and record the
Very
screen.
true.
But
right,
I'm
which is not allowed. I think there's a lot of, again, everything's new, but to me that seems like a problem in the making.
The concern is that you invoke the rule, meaning that you don't want witnesses hearing the testimony, and then they can step outside, be in a break room, and then off of a different tablet or something, watch the hearing on YouTube.
Right. At least if somebody's logging into Zoom as a participant to watch, or as a viewer, you know who they are, and there's a record who's there. I mean, what's one of the first thing that happens when you start any hearing? Please state your appearances for the record. And so now you have people in the room technically who nobody has any idea that they're even there.
Oh, lots to think about.
No answers. Just lots
No, we're kind of like learning this as we go along, and hoping that the courts are thinking through all the processes that they need and engaging with the bar to figure out good platforms, good procedures before implementing it. I mean, do you think this is something that really is adaptable to evidentiary hearings, or do you think we should be sticking to like the just the oral arguments with lawyers on motions, or the status hearings, or the scheduling matters?
I mean, my personal opinion, obviously I'm much more comfortable in a courtroom because that's all I know. But thinking of Houston, we've had some natural disasters like Harvey that shut us down for a while. Now this pandemic. And the reality is that our clients' needs don't go away and don't stop. And so in the situation of my hearing, my client wasn't seeing his child. And so if courts aren't scheduling hearings until, the summer, months will go by without him being able to exercise periods of possession, which isn't acceptable. So, is this the future? I don't know, but I do think that it's really important for what we do to make sure that we don't shy away from it and that we're not afraid of it just because it's uncomfortable or it's a little bit more difficult, because our clients need access to the courtroom.
Personally, I think it should stay. I've thought for years, at least your simple non-evidentiary matters, it's much more efficient to go through video or telephone as opposed to having all the lawyers go sit outside of on a crowded docket, especially those of us that practice in larger jurisdictions. I mean, I could be there on a simple, uncontested final hearing or even a motion to withdraw, and I may be waiting for 3 hours. So I think economically, it's much more efficient for clients. I think it's more practical. The only thing I would like to see is some of my hearings where I've done this, everybody goes and everybody waits in the virtual waiting room at a certain time, and you could still be waiting quite a while. Now you can multitask. I would like to think that as this progresses, I would love to see time slots where each case, for our motion calendar is supposed to be 5 minutes, let's say, but let's say each case gets 10, and each person is given a number and an order, and they have to be on 10 minutes early, and they have a period. I think something like that would make this much more practical, but that should happen with time. And I think even evidentiary matters, if you have a 15-minute evidentiary matter, something like that, or something that you can't wait on, the benefit is also accessibility to the judge, accessibility for your clients, not having to worry about childcare. It seems to me you should be able to get in a lot sooner. For us, I may wait 3 months for a 15 or 30-minute hearing, which is outrageous. And, I think that helps. The cases that I'm not doing right now by video are those that I know are very document intensive, or I really think the court needs to see one of the parties in person. And that may just be my own fear. I think the more we do these, that may change as well. But that's sort of how I'm deciding it. There's certain hearings I'm requesting now by video, and there's other ones I'm punting, although, everybody thinks their own belief on this. Our courts are technically supposed to open in June. That's never going to happen. I have a 2-day trial that got set on a contempt issue for August. And I can't imagine, what are we in May? In 12 weeks that we're all going to be we're in South Florida in crowded courthouses. I'm not going, even if it's open, I'm not going to do it. So these are all battles that we're going to have to do. We're going to have to weigh whether in the interest of justice for our clients, do we suck it up, do these, it may not be perfect, but do it by video, or do we wait what could be a year to get relief? Or do you bring people into a courthouse? And I think these are, more intellectual discussions that everybody is going to have. But for the time being, we're stuck with what we're stuck.
I mean, what are your thoughts on filing a motion either to reset your hearing as a remote or virtual hearing, or vice versa, filing a motion to say, I am opposed to doing this remotely. We need to wait that 15 months until we're going to be back into a courtroom.
I think it could go either way. We have some cases in my office where, and you got to be careful. You don't want to use this as a sword and a shield. You don't want to be inconsistent. Okay. I think that there's certain hearings that you may really want to do in person sitting here today. 3 months from now, that may be a whole nother story. You may realize that courts aren't opening so fast, or this isn't necessary to be sitting there, because even if we're all in a courtroom walking around, are we going to be wearing masks? Are we going to be wearing gloves? Are you walking right up to a witness and handing them a document and getting it back? I'm not touching that shit, So, I mean, these are things that we all have to think about practically. So, I think that as now we're in May, the way we're all looking at things now is probably very different than the way we were looking at them in April, which is very different than the way we were looking at them in March. So I'm sort of picking and choosing right now. I also think that I'm somewhat technologically savvy, I would say. And so I don't have the fears of using digital services to go to court. And not that I'm using this as an advantage, but I'm requesting hearings by video. And I think that I have certain opposing counsels that are not comfortable using it. And what it's doing is, it's no different than filing a motion that is never going to go, but you need to put on some pressure to get the other side to settle something. And I'm hoping that that's what's going to happen too. I firmly believe that these hearings and what we're dealing with in general should lead to more resolutions as much as possible. I'm a mediator too. I love doing the Zoom mediations. this should encourage people to stay out of court. This should encourage people to be reasonable and not stick their head in the sand and just say, oh, I want a judge to tell me. Because we all know the problems with that to begin with. And now it's just exacerbated by the technological issues. So yes, to answer your question, Melissa, I think that there's certain times that it would justify maybe filing an objection to a video hearing, but don't abuse it. Don't use it as a sword and a shield. Don't do it just to try to delay an issue, because we all have canons that we follow, and I think that would be unethical. But if you really truly cannot try an issue digitally and you can show for good cause, then I think at certain times you are going to have to make that objection.
Perhaps this is an academic issue, but what happens if there is a lawyer on the other side that isn't as tech savvy as you, Brian, and they want to call in by telephone? I mean, should the court be hearing this case where they can actually visually see someone, but they can't see the other side?
Well, I think it depends if it's a party or a counsel. Most people can log into Zoom. And I think if somebody says they're not able to, they're being disingenuous. That said, I don't think it should be necessarily a block. If you need the court to see someone, you can object. It's no different than, we have local rules that say when somebody can or cannot appear telephonically at a hearing. For us, it had to be a hearing of 15 minutes or less, and yada, 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 and then good cause shown. Those standards probably still apply, something along those same lines. But if you need to see someone in person, it's easy enough. You could send a Zoom link, and literally on your cell phone, it's one click, and boom, if you download Zoom, you're in the video conference.
Right. And I say that's probably reasonable for us as lawyers. I think a lot of courts and then court administrators are going to be having different questions because they're going to have self-represented litigants who might not have access to internet. I know our public schools are having the same debate about online schooling and access to the platforms.
Well, in Florida, and I assume it's similar in other jurisdictions, pro se litigants are held to the same standard as lawyers. You're allowed to choose to represent yourself, but if you do so, you're at your own peril if you don't want to follow one of the rules. We don't really have a lackadaisical procedure. And again, if somebody's able to go in, frankly, I think it's harder for a pro se litigant to file a pleading with the court on their own than it is to get on Zoom. If somebody can figure out how to file something on their own or navigate the court procedure, because frankly, when I look at the local rules and how to do it, if I didn't know it on my own, I wouldn't be able to do it. I don't think. It's too many steps, and it's all these words, and you have to go here and you have to go there. It's easier to click a button than it is to do that.
I think Melissa's point, though, is maybe, and again, it's probably academic, but to people that aren't necessarily in our private practice worlds, different types of proceedings, not in, my commercial litigation practice, your family law practice. So I think these are real issues that the courts are just going to have to face. And yeah, just
hopefully make consistent yet fair procedures.
Yeah, exactly. And I know, but I mean, some of the proceedings are still happening very, very limited in person, and things that are emergencies and so it's.
And that's a good point, Jamie. So here's the other thing, especially in family law, anyone who practices family law, how many times do you see the word urgent or emergency and emotion? Everybody's got to think twice now before calling something urgent or an emergency. And even our courts at this point, and it's getting a little more commonplace now, but we were having certain parties were completely denying time sharing and withholding children. Some judges find that abominable and they're slamming. Other judges in the same jurisdiction are saying time sharing is not essential. There will be no time sharing exchanges until the lockdown is over. So you got to know your judge, and you got to be careful on what you title a pleading and how quickly you're actually seeking the relief.
So while we're tying up, let me ask both the speakers, what are your takeaways? What are the real benefits you saw from doing this? What are the potential drawbacks that we all need to be looking out for when we get scheduled for our first video hearing? How about Jamie?
I think the bottom line is preparation is key, and that's on a lot of different levels, both what Jelena talked about in terms of practicing on the platform, practicing, sharing documents, what I was talking about, deposition, making sure your documents get to the witness, get to opposing counsel, get to the court, whatever the case may be. And then also practicing with the technology, practicing making sure you have a backup if, for example, your Wi-Fi goes out. And it's just preparation, even more so. Some of us can walk into a hearing and shoot from the hip and, pull cases out, and, doesn't take a lot of preparation all the time. That's not usually me, but this is just one of those times that we're in that I think preparation is just really paramount, and putting pants on.
Said like a Florida lawyer.
It's
How
too
about
hot
you,
here.
Jelena? It's too hot for pants. Well, Jelena, who's also in a very warm climate.
It's been very, very warm, especially the last 2 days, and humid. Exactly what Jaime said. I think preparation is key, and I can't help but think, the first time I was in a courtroom, and the first hearing I ever had, of course, I was terrified, and in retrospect, I was fumbling through it, and whether I had my exhibits organized or not, God help me, I didn't know what I was doing. But with time and with practice, obviously, you feel confident, and you know what you're doing, and you're able to get your client the results that they want. And so I think that a big part of this is just getting more comfortable. And it's outside of our comfort zones. And even if you're tech savvy, maybe you're dealing with a client who isn't, that has its own frustrations. So I just think that, comfort level, getting this to be our new comfort zone is going to go far.
All right, I want to thank everybody. Melissa just shared our email addresses in the chat. So if anybody has questions or follow-up or feedback, feel free to shoot us a message. We'll be back in 2 weeks. Start following us. Go to our website, techtalklaw.com. Follow us on social media. Send us ideas for discussions. And forward us cool virtual backgrounds for Zoom.
Like the Tiger King.
Yeah.
Yeah, that's the best one.
I think this is going to be an evolving discussion. I think we could probably have the same discussion a month from now once more people are doing this, and it'll be an entirely different discussion then.
Are you talking about Tiger King or Zoom hearings?
Zoom hearings, but
Probably
maybe Tiger
both.
King too. Well, thanks so much, everyone. Happy Cinco de Mayo.
Thank you, everyone.
Happy. Bye, guys.